All right, welcome back. And I'm now being joined on the program from Abuja by Frank Tietie, who is a human rights lawyer and, of course, has actually been saying so much about this issue of political defection lately. Mr. Tietie, thank you very much for joining us on the program. Let me quickly ask you what you make of the court decision now in the case. I'm talking about the Federal High Court verdict now in the case of Senator Sonny Ogboji.
Interestingly, the court has simply made a clear pronouncement that clearly interprets the position of the Constitution. There is nothing unusual, there's nothing strange about the position that the court has taken. That has always been the position from the outset. And for the sake of certainty and order, that would have been the expectation by several senators who have defected from their political parties. By themselves, they ought to have resigned, or the Independent National Electoral Commission itself should have actually declared their seats vacant. But we wondered why there was so much filibustering, this unnecessary delay, unnecessary political correctness that has created this degree of uncertainty. Even when the Federal High Court has now come to make this declaration, people are still wondering. That has always been the position from the outset, and nothing new has the court declared.
And now, because you talked about certainty, let's face it, it's actually not the first time that the court would be making a pronouncement on this issue of political defection. I still remember that about 2 or 3 years ago, a court actually made, I think a court in Akure, a high court in Akure actually made a legal pronouncement when a member of the State House of Assembly actually defected. But it appears, you know, for sometimes when the court makes a pronouncement, for it to be given some kind of force, if, for instance, like in the case of the Senate and House of Representatives, if the leadership of the House or Senate decides not to move against whoever that judgment has been, you know, the court has made a pronouncement against, nothing happens.
Yes, it also depends on the weight of, I'm talking about the political weight of the individual concerned. Saraki, for example, ought to have been affected by when he decided to move to the PDP, even as a sitting as a Senate president. There was no case of defection, a division in the APC as established. It didn't matter whether Buba Galadima, at that point, a prominent member of the APC, declared that there was a reformed APC. There was no clearly recognized division in the APC. Yet the Senate president at that time defected to the PDP and nothing happened. The same thing applied to Senator Godswill Akpabio, who for no reason whatsoever, no grounds whatsoever, moved from the PDP to the APC and nothing happened. It was the same court in one kind of judicial confusion that also gave protection to these same persons. Now, it is important that the Supreme Court, you know, makes a pronouncement on this. But you see, this is a clear provision of Section 68, subsection 1, paragraph G, that unless there is a division, you cannot leave the party that sponsored you into the National Assembly or the House of Assembly before the expiration of your tenure. You cannot leave unless, if you do leave for another political party, your seat will be declared vacant. And I've always held the Independent National Electoral Commission responsible. The INEC doesn't really need to wait for a court to make a pronouncement. The moment it sees a set of facts that describes the situation that, look, this Saraki has defected from the APC to the PDP and there is no clear case of division, it is not convinced as a commission that there is division, INEC itself ought to be responsible in declaring such seats vacant and then proceeding to conducting by-election.
Why do you think INEC has not been able to do that all this while when the provision, as you said, of the Constitution is quite straightforward and clear?
Much has been talked about political will. But when we are talking about a commission that is independent, that is impartial, that has a constitutional responsibility, a state responsibility to the people of Nigeria, it doesn't need to be politically correct. It should do what it is written in the law, what it is directed to do according to the Constitution and according to the Electoral Act. I may not be able to fathom a reason why INEC has been floundering on such matters. But clearly, if there is a failure, if there is uncertainty, if there is confusion in this matter, it is because INEC has not taken a position. It is INEC that should be convinced that there is a division in a political party. It is INEC that should be in the forefront in declaring that, look, this defection is illegal and we will consequently act upon such an action. INEC is responsible. I may not know the reason why, but it's from now on should realize that we Nigerians realize that it is failing in its responsibility, creating a state of uncertainty whenever it keeps quiet when these things happen. And you know that our judicial process, we really cannot count on it, because sometimes the era of injunctions and counter-injunctions, counter-restraining orders and all the rest will exacerbate the problem that we have. It is important that we have speedy adjudication of these matters, because some of these declarations by these courts have become inconsequential by reason of time, and it's painful that that people who should have been properly represented were not represented, and it makes nonsense and a nullity of all of these processes. It's painful and sad.
Now, do you think part of the reasons why INEC has actually failed to take action all this while is just because most times INEC would look at the caliber of the individual involved? I mean, like for instance, in the case of the Senate President and the Speaker of the House of Representatives, or even Godswill Akpabio at the time he was the minority leader, these are highly placed individuals with, top positions. So could we say that's one of the reasons INEC has actually failed to act?
I think INEC was overwhelmed in the build-up to the 2019 elections, and was doing everything possible to minimize confusion. But in that process, it created more confusion, because the best way in approaching matters like this is to consistently be on the side of the law, beginning from the Constitution to the statutes, and then established practices and procedures by INEC itself. So in failing to take position, INEC allowed all of this, and then the courts cannot also be trusted on the issue of speed, because when it takes so long for the courts to make determinations and then to give orders that cannot be enforced. For example, asking the person who has illegally occupied the seat as a senator or House of Reps member to now refund monies that it has, he or she has expended over or collected as salaries. It's a nuggetry. It's nearly impossible. And we've seen all of these judgments in the past, and none of them has been able to be to get monies refunded back to the coffers of the state. So let us not use the judiciary, and as it appears, as a way of giving soft landing to persons who illegally occupy the seats, and knowing that the judiciary will render useless because of the reason of delay, render useless the quest for justice. INEC should have mustered enough courage to take the position and wield the big stick whenever any person runs foul. It doesn't matter whoever the person is, whether it's the Senate President, as in the case of Saraki, or the minority leader in case of Godswill Akpabio, or just even a member of a House of Assembly. INEC should take a position, and we expect that it should change in this new dispensation.
And I think you're quite right, because if, for instance, like in the case of Saraki and the 52 others that Justice Okunabang is currently sitting on their case, if, for instance, INEC had taken any action at all on them, they would have been forced to go to court, and not a situation where another group, the Legal Defense and Assistance Project, is now the one going to court asking the courts to declare their seats vacant. Because you would expect that you would expect to see a situation where INEC comes in, declares their seat vacant, and then let them go to court, and not the other way.
Yes, of course, because these persons have an array of legal advisors who would have told them in clear terms the provision of section 68, subsection 1, paragraph G. Yet, they had the courage to do so, because we are in an era where political correctness will stifle institutions of state like INEC from carrying out proper actions that are directed by the Constitution and by the Electoral Act. So that is the debacle that we find ourselves. And now you will find that that decision can be taken based on technicalities, and then nothing will also come out of it. So those who are saddled with the responsibilities of discharging state directives must do so without fear or favor. And INEC in this case, I have always called on INEC to exercise its powers, but it must not wait for the government or wait for the more powerful body to use the judiciary to harass it or to stifle it. It's unfortunate that INEC has refused to take a position on this matter. That's why the confusion has reigned supreme until this moment. The court has again reenacted the position of the law.
Could we as well say that, look, until the Supreme Court actually makes a pronouncement on this, until one of these cases actually gets to the Supreme Court and the Supreme Court makes a definitive pronouncement on this, you would have a situation where, you know, politicians will continue to exploit some kind of loopholes now to continue to defect, if you like. So, but if there was a definitive pronouncement from the Supreme Court, then they just would not do it again.
I sincerely do not think so. I believe that with an INEC that is resolute in taking a position, the situation will change faster than we ever thought. Now, the pressure should be on INEC and not on the courts. INEC should take a clear position by acting, by declaring such seats vacant, and then proceeding to conducting by-elections for those seats. And then the entire scenario of defection will immediately change. So it requires an administrative action more than a judicial action.
And of course, if that is done, then we definitely would not see the kind of thing, because last year was actually an embarrassment before the election. The kind of defection we saw, just too massive.
Yes, because those defections were politically expedient, however illegal, however unlawful that they were. Now, the electoral umpire ought to have taken the position by railroading everybody back to what is legal. So we cannot begin to operate on the altars of political expediency, and then we might eventually get confusion, and then this will lead into political conflicts, which we cannot afford as a people and a country.
Mr. Frank Tietie, thank you very much for joining us on the program and for the insights you have provided there. Well,
Many thanks.
As Frank Tietie, who is a legal practitioner and, of course, a human rights activist. We'll take a short break, and when we come back, we'll switch focus. This time, we'll be talking about education. Stay with us. On Deji 360, we don't just ask the questions. What is wrong with amending the Constitution the way the National Assembly members have been doing it? We seek answers.
Constitution is constituent. Our problem is not lack of laws. Our problem is lack of the willpower to implement our laws.
Answers that provide clarity.
While we negotiate, we should try to make it a point that the girls must be complete.
The clarity you need to make informed judgment so that you can make the right decision and take action. People are saying it is you politicians that are responsible for this, that you are the reason why this is happening.
All these dollars that call themselves governors in this country?
I wish we had people like Tony at the National Assembly.
God forbid that I go to join that band.
Deji 360, providing clarity to issues.